Case number 20-1025 et al. Environmental Health Trust et al. Petitioners versus Federal Communications Commission and United States of America. Mr. McCullough for the petitioners, Ms. Boiselle for the respondents.
Mr. McCullough, good morning. Please proceed.
Good morning. May it please the court. I'm W. Scott McCullough presenting argument on behalf of the 14 petitioners in these consolidated cases. One of the petitioners recently contacted the FCC to seek redress for injuries she attributes to RF exposures. The commission representative said, "We don't deal with humans, only frequencies," and hung up. That conversation encapsulates the FCC's approach here. By closing the inquiry, the commission failed its duty under the Communications Act to consider all potential health and safety impacts of radio frequency emissions on humans. It ignored over 1,000 peer-reviewed studies showing that exposure to non-thermal radiation at authorized levels evokes a clear biological response beyond mere tissue heating, and it leads to multiple forms of harm. It ignored direct human evidence of current injury. It failed to comply with the APA and NEPA for similar reasons. The commission has a substantive duty under the Act to have and maintain adequate emission limits beyond
Can I ask you a question about standard of review? You say that we shouldn't give the commission any heightened deference in this case, citing Fox Television among other cases. But can you point me to any instance where we or the Supreme Court have not given heightened deference to an agency decision involving scientific judgments?
Well, there are various levels of discretion that are given to agencies depending on the circumstances. This court and the Supreme Court has ruled that in the context of a petition for rulemaking, there is very high discretion. The problem here is this was not a petition for rulemaking. Indeed, if you look at what happened in the inquiry, the commission did engage in rulemaking functions. It established requirements. It extended its 1996 rules to situations, usage, and indeed even frequencies that were not covered by those. So it was functionally engaging in rulemaking here. And that's the level of deference that should be applied. But even under the highest level of deference, the commission still has to engage in reasoned decision-making. It still has to address all the material issues. It still has to respond to material comments. It has to look at the entire record and explain its reasons.
That sounds a lot like the standard from if we were reviewing after notice and comment rulemaking, whether they had sufficiently explained their final position and responded to substantial comments and concerns and addressed the record as a whole. What I'm struggling with is we're not at that stage. We're at the should they engage in rulemaking at all. And I understand your arguments about things that they didn't respond to with much of any sufficiency. But I'm searching for case law or precedent that says in this context, how much they have to say about contrary evidence in the record.
Well, my first point is that regardless, even if you are giving them the highest deference that is given under any circumstances, which we think they were engaging in rulemaking here.
Okay, let's assume I don't. Let's assume this for these purposes. Look at we have a body of case law on petitions for rulemaking and how inaction or denial of those is treated. So within that body of case law, can you explain to me what our rule would be that they violated here?
This was not a petition for rulemaking. This was a proceeding.
I understand, but
the commission
I think that's the most analogous
itself.
one for this stage.
And it was very much like in the Fox case, a notice of inquiry. And, in that case, this court did not give the highest level of deference. But no matter how much deference you give them, the problem here is you just simply cannot say that the 6 paragraphs the commission dedicated to addressing the inquiry can adequately deal with all of the evidence in this case. It did not mention all of the 1,000 peer-reviewed studies. It gave scant mention to only 3 items the RASMINI, the NTP, and the bioinitiative. And it
Which are the
dismissed.
ones you sort of rely on most heavily, right?
Well, we rely on those, but we also very much rely on the underlying science
Mhm.
and the studies that were used.
They don't
for
have to address every submission. Can we agree on that? They don't have to respond to
They
every.
do not have to address every submission. They have to address every material submission. But
Is that
even more
true?
important,
And is that true in this state? Where have we said at this stage, as opposed to, again, at the end of notice and comment rulemaking, that they have to respond to every material submission?
we are not contending that the commission had to go by every single one of the 1,000 peer
I said
reviewed
every
studies.
material, you just said to me every material one. So now I'm asking you, where have we said that at this stage? This is
I think the
preliminary
Fox
stages.
case, I apologize.
No, no.
I think the Fox case stands for that proposition. But no matter what scale of discretion,
And what, can you tell me
you-
which page on the Fox case you're relying on?
well, and I do apologize. Of course, the court addresses all of these things throughout the entire Fox case.
All right, if there's
But-
particular language or page you want us to focus on, maybe you could just tell us at rebuttal. I don't want to hold up your argument here. I'm sorry, I thought maybe you had something in particular in mind.
Well, I'll be happy to supply a post-submission on this, but you know, the real and fundamental point here is that the commission does owe some duty substantively. It recognized that it had a duty when it opened the inquiry to give a full examination and explain its rationale and assure the public. In order to do that, it had to give some analysis to the evidence in this case. It did not mention a single one of these other studies. All that it did was mention the bioinitiative report and then dismiss it because it did not solve the problem of being able to also still provide service. It did not get into the underlying science that shows the level at which there are adverse impacts from exposure.
Can we talk about the role of the FDA here? Because the order said that no expert health agency expressed concern about the condition's radio frequency exposure limits, and that the FDA said no changes were warranted, in that Congress tasked the FDA with evaluating the health effects of radiation. And that's something that the FCC also argues in their brief. So, so what was wrong with the FCC relying on the FDA in this case?
It is permissible for an agency with jurisdiction to rely on agencies with expertise. But as was the case in the city of Boston, the city of Boston case, the agency with jurisdiction, when it looks to the agency with expertise, what that does is require the agency with expertise to itself explain its rationale and how it went about this. If you compare the FDA response here to the analysis that the court looked at in the city of Boston, you will find a magnificent difference. The problem also is the FDA was concerned, its letters, its short missives here looked only at cancer and only with cell phones. It did not look at all of the other adverse effects that the evidence shows occur here beyond just cancer. Finally, I do need to point out that the FDA is not necessarily the agency with expertise. The NTP study was contracted by the FDA. It looked to another agency within the Department of Health and Human Services, the NTP. Presumably, that's the agency with expertise. And so, you know, I think if you want to find the agency with expertise here, it would be the NTP. I will point out that the NIEHS, yet another DHHS agency, conducted a peer review of the NTP study, in which the criticisms, as short as they were, by the FDA were considered. And that peer review panel, conducted by the NIHCS, another sister agency, rejected the FDA's concerns and in fact elevated some of the things that were found in the NTP study. So,
Can I ask on so the agency, the FCC here relied heavily on the FDA and its analysis because of their medical expertise. Have you ever had an opportunity? Did you have an opportunity? Is there any procedure by which you could either challenge the FDA or go to the FDA and prompt them to look at your medical evidence and change their position? It seems this is a very odd statute in that they have the technological role, but they don't have the medical knowledge, and you're asserting injuries that are medical injuries, physical injuries to bodies, in which the FDA seems to have more expertise. It almost seems like the one you should be talking to is the FDA. Have you talked to the FDA? Have you given submissions to them? Did they look at these types of reports?
There is no information in the agency record here on that point. There is information in the record where people near the end of this proceeding responded to what the FDA director said. But we do have a fascinating jurisdictional situation here. There is no direct way to challenge the FDA determination. But since the commission was relying so heavily on the FDA, I think what that means is you now need to look at the FDA letter and see what it addressed and whether the FDA letters reflect some kind of reasoned decision making. And we submit it does not. It is just as cursory as the FCC's 6 paragraphs here.
As I read the FDA submission, it was focused exclusively on cell phones and didn't address other devices.
It was exclusively on cell phones, and again, exclusively on cancer. It did not address some of the other NTP findings on other adverse biological effects. And I do need to point out that the commission's representation that all of the other sister agencies either did not object or agree, it is just belied by the record. The Interior Department has expressed concerns. The EPA has expressed concerns with the thermal-only approach. Obviously, the NIEHS doesn't agree. We have the Access Board findings. We have the CDC recognition of radiation sickness as a disease. It is just simply not correct to say that the federal government and all of its agencies is entirely aligned on this question.
But no one has proposed any specific change in standard, right? And you can't point to any international standard that is stricter or more restrictive than the US standard. Am I correct on both of those statements?
There are some more restrictive standards, and there are some more all-encompassing standards.
What more restrictive standards did you cite in the brief?
Well, for example, I can certainly cite to the commission order itself, although it is not in the notice of inquiry. As the commission notes in paragraphs 122 through paragraphs 124, when it comes to some of the frequencies that the commission applied its regulations to, which were not in fact covered by the 1996 ones, specifically under 100 kilohertz and over 100 gigahertz. Some of the international standards are more restrictive, especially at the lower end of the band, than the commission's ones are here. If you take a look at, for example, and you may not have it in front of you, but note 328, when they're talking about neurostimular responses to low frequency emissions below 100 kilohertz. The commission actually recognizes the very symptoms that we recite for what we call radiation sickness. And the international organizations have made special provision for that. In the part of the notice of proposed rulemaking, the commission proposes to make some changes to its regulations to more or less align itself with these international regulations, but it did not do so here in the notice of inquiry. At present, under the rules, for purposes of these regulations and these frequencies, where the commission had not heretofore applied its rules in 1996, these rules now apply as a result of the notice of inquiry. The commission did indeed extend its 1996 rules to activities, frequencies, technologies that were not addressed in the 1996 orders. And that is why we say this was functionally, although not in name, a rulemaking. It made new rules for all of these new things that were not contemplated in 1996.
I understand that argument, but what the FCC says is that basically in all of the comments, there's a lot of sound and fury, but there's no specific recommendation other than one, I guess, from the bioinitiative report that says set the limits, 1 million times more restrictive or 1 billion times more restrictive. And they say that the technology can't work if those levels are that low. I didn't see any rebuttal to that point. And the only rebuttal I saw in your brief in the reply was, well, the bioinitiative report suggested a path forward. Well, when I read that report, the path forward I see is, well, there needs to be more study done, but there's no specific regulatory limit change that it proposes. So do you disagree with anything that I've said there? And if not, why isn't that an undermining your position?
I see that I'm somewhat over my opening time. May I still
Go
respond?
ahead. Of course, go ahead.
The first step to solving a problem is recognizing that there is one. And the bioinitiative's main point was there are these significant aspects of the problem that the thermal-based rules do not address. And that is that there are biological responses that occur. There's biological responses, many of which are adverse, when you are exposed to authorized emissions. The bioinitiative said, based on its analysis of the studies, here is the point at which there is a response. The bioinitiative was not necessarily recommending that emission limits be taken immediately all the way down to the point where there is a biological response. Their main point was you need to adjust your rules so that they are biologically based, not thermal based. It then recommended collaboration between the scientists who understand biological responses, the commission, and those who design networks to try to find the point where you could have services with less harm. And so the bioinitiative was not saying take limits down all the way to this level. It was saying recognize there is a biological response and let's find a way to adjust standards so that we lessen the harm while still maintaining the ability to provide service.
How does that translate into error by the commission here?
It does, because what the commission demanded in the inquiry and in the order, it said, we're not going to pay attention to your science unless you also solve the service utility problem. And the entire point is there's two problems. The problem is the biological response. And then you have to figure out a way to address that within the context of being able to still provide service. This was a notice of inquiry, or at least it was supposed to be. In the actual rulemaking would be the time to find the actual emission levels that would serve both needs. And so the commission just completely misconstrued and misapplied what the bioinitiative was saying. They were not saying take it down to this level.
Okay,
were
can
saying
can I
recognized
just
biological-
interrupt you for a second? Because there's something that I thought was very interesting about the briefing here that I'm trying to get the take of both sides on. On page 37 of the FCC's brief, they refer to 21 USC section 360 II. In as part of their argument that the FDA is really the kind of expert agency on human health impact of radiation of this sort. And that particular statute says that the FDA is supposed to kind of get this advice and expertise from a technical electronic product radiation safety standards committee, which is created a couple of sections later in 360 KK, subparagraph F. And that committee is supposed to have, of diverse representation of people from industry and scientists and medical professionals, et cetera, to basically kind of do what you're saying that should undertake the sort of analysis that you say should be done. It's interesting to me, though, that you don't reference this committee at all in your briefing. It's also significant to me that the FCC doesn't reference that Technical Electronic Product Radiation Safety Standards Committee in their briefing, even though that committee is supposed to take the lead on testing things like cell phones and the testing standards and the standards that they're supposed to meet. Why is it that you don't seem to think that this statute has any relevance, or at least you don't talk about it in your briefing?
We do not talk about that in our briefing because it has no relevance to this proceeding. We are dealing with the Communications Act, which has given to the Commission the exclusive right to set emission levels for all point sources. The FDA's jurisdiction over some radiation emitting devices is far more limited than that. And while it is true that the FDA itself would have jurisdiction to establish rules upon proper petition, that would be the Secretary of the FDA, not necessarily the division that handles these that Dr. Shura is with. And so we have not only a procedural and jurisdictional problem, there's also just nobody seems to have invoked or sought a rulemaking from the FDA that would have set in process the committees and such like that are described in the statute you cite. We are dealing with the federal
Does that committee exist or not?
I beg your pardon?
Does that FDA committee exist or not?
There is no evidence in the record on that as far as I know.
Do you just know whether it exists?
I do not know. I apologize. Remember, in this context, in looking at it from more or less a NEPA perspective, the commission is trying to rely on the FDA as an agency with expertise, where the commission is the agency with jurisdiction. And the problem is the FDA is not necessarily properly considered an agency with expertise under the environmental laws. It deals with human health, not the environment. And so, I truly do think that the commission needed to look to far more than and rely on far more than a couple of letters from an FDA director. And once you look at those letters to begin with, they simply do not pass any kind of muster for reasoned decision-making if this is what the entire case turns on. It does not at all compare to what this court approved in the City of Boston case, to again cite that example.
All right. If there are no more questions, then we'll give you some time in reply. We'll hear from Ms. Boiselle.
Good morning. May it please the court. Ashley Boiselle for the Federal Communications Commission. As I think the panel recognizes, the FCC was not writing on a blank slate in this case. Instead, it was seeking scientific evidence and recommendations on the effectiveness of radio frequency emission limits that it adopted in 1996 and that have been upheld against judicial challenge twice before. As both this court and the Second Circuit have approved, in making this evaluation, the FCC reasonably relied on the views of federal agencies with primary jurisdiction in public health, as well as recognized standards bodies. The FCC relied on substantial evidence.
Yes, I mean, it's so, and just, first of all, I guess I should back up. Do you know whether this committee that Judge Wilkins referenced within the FDA even exists and whether it has spoken on this issue?
I'm not familiar with the committee or what its status is.
Okay. So in the notice of inquiry, the FCC flagged that it wanted to get input, including from these expert federal agencies, sister agencies, information on what had changed since 1996, and that is the ubiquity of the devices, the different types of devices, the sheer volume of them, and intervening developments in analysis of medical consequences, and in both the introduction and then even in your final decision here in your second report in order, there's lots of discussion about how there's so many new devices and people are using multiple devices. They're using them, way more people are using them, and way more people are using them all the time or through extensive periods. This was even before the pandemic when we're now living on this stuff. But even before that, the amount of usage, the number of devices used often simultaneously, the age range of people who are using these and how long they're using them. That was all quite sensibly what the FCC asked for. The FDA came back and talked about cell phones and cancer. How was it reasonable for the FCC to rely so heavily on a response from the FDA that there's no indication relied on this specialized committee and did not address the very things you asked for information on: other devices, the use of multiple devices, and physical harms other than cancer? How is that reasonable, even with the super deference you get at this stage?
Well, first of all, we didn't rely exclusively on the FDA's representations about the state of the science. You're right that their statements spoke specifically about cell phones, although their public
rely on that at all. Other than
I think
what it said about cell phones, but that just simply didn't answer the question asked. So how was it reasonable to rely on it? I don't want to hear, I just want to know how it was reasonable to rely on something that was not responsive to the inquiry.
Sure, for two reasons. One, cell phones are used in close proximity to the body, and the power of an emission decreases exponentially with distance. So cell phones are the device that is creating the most radio frequency emission when compared to other devices and other base facilities. Second, we have aggregate limits that apply to fixed facilities. Those are set forth at 1.1307B3, and they require that all
I'm not talking about fixed facilities. I'm talking about watches. I'm talking about iPads. Okay, those are not fixed facilities. So
sure.
And then I'm also not talking about just using a phone and holding it up to your ear. People don't use their phones, hardly use them for phone calls anymore. They're constantly in the hand, not 2 centimeters away. They're constantly in the hand, and the fingers are constantly on them. And so I'm just trying to understand how the FDA coming back and talking about cell phones that are in a holster, or nobody keeps them anymore, or are in a purse, or they're not being used. Is it all, and looking only at cancer, is it all relevant to an inquiry, again, into the effect of this radiation frequency from multiple devices that are used in entirely different ways now, an entirely different volume, and throughout the population, including children who live on iPads?
So as I said, the FDA said in its letter at JA 8187 that it was engaged in an ongoing review of the evidence in this area. And then, as you say, it represented a specific conclusion with respect to the National Toxicology Program's research on cell phones. But that was coupled with representations in our termination of the notice of inquiry at JA 12 that the World Health Organization had found no substantiated adverse effects from fixed facilities. So this wasn't an inquiry that was limited narrowly.
You are way more expert than me. Is an iPad a fixed facility?
No, an iPad is not a fixed facility.
Is a watch a fixed
No,
facility? No.
Right.
Okay. Is a wireless laptop a fixed facility?
No, but
When they
but
talked
with
about, when the notice of inquiry talked about the ubiquitous use of devices, was it talking about fixed facilities?
no, not exclusively,
Okay.
but I was going
No,
to
no,
get
no,
to
but
that.
I don't think that was, okay, I get that, but I just
I
said,
apologize for
the
not
fixed
being
facility
responsive.
stuff, I don't, to me at least, doesn't feel responsive unless I'm misunderstanding it. I'm really curious about all these other devices.
Absolutely. So
Where
with
would that
respect
go?
with respect to mobile and portable devices, we said at paragraph 143 of the notice of inquiry and paragraph 67 of the order on review here that there didn't need to be aggregate limits, that we didn't have a concern about the aggregate effect of transmissions from these mobile and portable devices because they
I'm
tend
sorry,
to be
which-
used.
Sorry, I'm sorry.
It's okay.
Is it
It's 67.
Are we talking JA 67 or 67 reported?
It's paragraph 67.
Sorry.
It's JA 35 to 36.
Okay.
So we explained in that paragraph that exposure from mobile and portable devices tends to be a more localized exposure when they're held close to the body. That would cover things like a watch or a tablet held in the hand or a cell phone. And that exposure, because it's more localized, tends to doesn't need to be aggregated because the whole body exposure is much more diffuse. So we addressed the fact that
And what
aggregateness in
expert
our view-
agency, what other expert agency was the one that addressed that for you?
we were making that judgment in our own technical expertise that the effect of these emissions was not significant in the aggregate and that therefore there didn't need to be any kind of aggregate limit. But with respect to our reliance,
That.
pardon me?
How did you decide? I mean, these things are strapped onto the arms and in the hands a significant part of the day. How was it that you decided that that was not a significant change from what you had looked at in 1996?
Well, there are no substantial adverse effects from exposures at the existing levels. So the fact that they're strapped on the wrist.
Those, and how did you find that? Was this through your 2.5 centimeter test?
Well, no. What I'm doing is referring to our explanation of why the existing limits continue to be sufficient. And what we said in terminating the notice of inquiry is that the scientific evidence, and we relied on the FDA, but we also referred to other expert organizations and bodies, that the scientific consensus had not changed. And I think it's a mistake to characterize what we did as relying exclusively on the FDA's conclusions, because that's not what we did here. We also looked to the views of, as I said, the World Health Organization at JA12, the International Commission on Non-Ionizing Radiation Protection, the National Toxicology Program scientists themselves said don't rely on this rat study and extrapolate to humans. So it was a broader inquiry, and we engaged more broadly with the experts in this area in drawing the conclusion that there were no substantiated adverse effects. And your question, I think, goes.
I see what you're talking, in some paragraph 60 section, you say that people are worried about cumulative ones. Exposure from fixed RF sources will vary, but we're not talking about fixed RF sources. And so where do you say for non-fixed ones? I'm sorry, I'm not reading the paragraph. Maybe it's the way, I'm not reading it with your expertise. I'm missing something. Where are you talking about non-fixed in paragraph 67?
We say that the location, let's see, sorry. When the RF sources are close to the body, they will be exposing smaller areas of the body. It's at the end of that paragraph. And separated sources will accordingly expose different areas of the body without overlap.
Yeah, that's just descriptive factually of what happened.
If you keep reading, so it's 67 leads into paragraph 68. We note that the exposure from each portable or mobile device near a person will generally involve low total power absorption while being highly localized and will not result in significant contributions to whole body average.
And what are you
SAR, which
citing
means
for that
specific.
conclusion? I don't see any authority cited or any study or any explanation of how you came to that conclusion, other than that just conclusory statement. The footnote.
You're correct.
So
Well, you're correct. How did we decide that the localized exposure would be absorbed in our,
multiple localized exposures for prolonged periods of time?
how that would not be harmful?
Yeah, how did you decide that?
Well, again, I think you have to link the observations here with the observations we made in concluding the notice of inquiry. You're correct. There is no footnote here, but if you go back to the resolution terminating the notice of inquiry, we said repeatedly that there was no evidence of any effect, not just cancer, any illness from radio frequency emissions below our existing levels. And in fact, we said below, at, and sometimes even above our existing
And that one
levels.
said, sorry, can you point me to that paragraph where it said, where it was addressing cumulative impacts? As opposed to
Again,
setting-
I apologize if I'm not being responsive to your question, but the cumulative effects are addressed here in
But
addition
then
to
you're referring back to,
1.1307.
and you're referring back to findings that were not themselves cumulative.
No, the scientific conclusions here are cumulative. The scientific studies that the FDA and others have looked at, and
No, the FDA didn't. The FDA was only talking about cell phones. That's my point. That's what I'm, there could well be, it's a very big record and you know better than me. There could very well be something where it was clear that you were relying on either your own determinations rather than just conclusions, or there's another FDA somewhere else or another agency talked about cumulative exposures from multiple devices over a prolonged period of time for physical impacts other than cancer. And is that, you're telling me that was made at the beginning, cumulative?
I don't know that we used the word cumulative in terminating the notice of inquiry, but the statements that we made.
That's what you meant. What paragraph are you talking about? Did the FDA ever talk about anything other than the cell phones?
In its public statements, it makes broader statements about the science.
I only talked about cell phones. That was the only science it had to back it up, right?
I think that most of the FDA statements were about cell phones, but again, those were supplemented by representations by other entities.
What other?
The state of the science. Again, the World Health Organization, the International Commission for Non-Ionizing Radiation Protection, which also, pardon me?
Just to be clear, so, and they talked specifically about cumulative exposure from the use of multiple devices for prolonged periods of time. As you've noticed, this was the whole reason you had your notice of inquiry, these changes. And they talked about those specifically.
The studies that were conducted or the scientific conclusions reflect the conclusion that even the cumulative effects are not harmful to human health.
They're mobile devices, these wireless devices, not of fixed devices.
Yes, because the only substantiated harm is a thermal harm at this point in time. And what we know is that at 4 watts per kilogram, we start to observe thermal changes. There are no substantiated adverse effects below that level. And as it is, our standards incorporate a substantial safety margin. They're 50 times safer than that 4 watts per kilogram.
Only looking for thermal effects, but not looking for non-thermal effects, right?
We're not, the limits address both kinds of effects because the only substantiated adverse effects are thermal ones. And we acknowledged evidence on the other side. We acknowledged that much of the record was not scientific. That which purported to constitute research evidence lacked any persuasive case as to its value or significance. We acknowledged 3 of the 4 major studies that petitioners rely on in their brief and explained why they didn't provide any basis to reevaluate our limits. And again, going back to the panel's questions at the start of opposing counsel's presentation, the standard of review is quite high here. This is not the kind of case that presents the rarest or most compelling of circumstances in which reversal is required. We based our decision on substantial evidence, as the Second Circuit and Cellular Phone Task Force and this court in EMR Network held. It was reasonable for us to rely on.
Can I explain my problem? I'm just going to be very upfront with why I am inclined to rule against you. So I want you to tell me why I shouldn't have the concern that I do. So I misstated earlier when I said you referenced on page 37 of your brief, 21 USC 360 II. It was page 23 of your brief.
You said that.
And you say that Congress directed the FDA to establish an electronic product radiation control program designed to protect the public health and safety from electronic product radiation. the statute that you cite there is section, it's 21 USC section 360 II. When I read that, it says that basically the way that that is done is that a committee that is established in a cross-reference to 360 KK will be established that will review these standards for testing and emissions level. Okay? But you don't reference that committee anywhere, and I don't see anything about that committee mentioned in the administrative record. Then later on in your brief at page 37, you say not to worry because the FCC stands ready to consider changing exposure limits in appropriate circumstances. And you refer to a radio frequency interagency working group that maintains a continuing dialogue between the FCC and the FDA about these issues. And that's referred to in a letter. Or you say that it's referred to in a letter. But when I read that letter, I don't see any mention of that working group. And I don't see anything in the record that says that that working group actually exists or looked at any of the evidence in this case. So the problem that I have is that you say that you're relying on the expertise of the FDA, but the entity that Congress specifically said to review this committee, you've given us no evidence that this committee has looked at any of this. And then you say that in the future, to the extent anything needs to be looked at, it's going to be looked at by this working group. But I don't see any evidence that the working group looked at anything this time. So why shouldn't I send it back for the relevant working groups and the FDA to look at this record? Tell me why I shouldn't, my vote shouldn't be to do that.
So with respect to the working group, it does exist and it is an ongoing project. With respect to the omission of any reference to this committee in the order terminating the notice of inquiry, we did formally solicit the views of all expert agencies in the notice of inquiry at JA 165. We made very clear that we intended to rely on them. We were very interested to hear their views, and the views that we received we took into account. And I think that that's all that's required here. We explained why our conclusions were what they were based on the representations that we received.
Is there anything in the record that says that the FDA asked this radio frequency interagency work group to review this and they weighed in, or anything in the record that says that the technical standards, et cetera, committee that was created by statute reviewed any of this and weighed in?
There's nothing that says that specifically. And pardon me.
Is the answer no?
The answer is no on that specific question, but I would just point your attention to JA 8187, where the FDA says explicitly, they acknowledge 5G specifically, which goes to Judge Millett's questions about the proliferation and ubiquity of personal devices, but they say FDA is responsible for the collection and analysis of scientific information that may relate to the safety of cell phones and other electronic products.
So why shouldn't we as a court reviewing this say that at a minimum, FDA should tell FCC and by extension tell the public and any court reviewing this that the expert bodies within it reviewed the materials that were submitted in response to the notice of inquiry, i.e., if we want to say this interagency work group is the right body, or if we want to say that the committee that Congress required the FDA to establish is the right body. But one of them, why shouldn't we at a minimum say before we believe that we can allow kind of any sort of deference to the FCC relying on the FDA, we need to know that the right people at the FDA actually looked at the materials?
Well, I think that there's nothing in the statute that suggests that the committee has to speak through the committee. I think that the FDA as the agency charged with keeping abreast of the science in this area, can speak to the state of the science. And it does refer to its ongoing monitoring activities in its letter to the FCC at J8187. And this is extra record material, and we're not relying on it for you to uphold the agency's decision, but the FDA did release a review of the scientific evidence in 2020, and its conclusions were consistent with the conclusions that
But
the
we
FCC
can't
drew
consider
here.
that.
No,
Under
we're not
Chenery,
arguing.
we can't consider that.
That's absolutely right. And we're not suggesting that you need to consider it to uphold the agency's decision, but I think it does confirm the centrality of the FDA to this
But
area.
the FDA, it's not just that we don't know that they asked their experts. We don't know what they asked them, because all we got from the FDA is cell phones and cancer. We know whether, is it reasonable for the FCC to take the FDA's representations at face value without verifying that the relevant experts have looked at the questions that the FCC actually asked when they get a report back that only talks about cell phones and cancer?
I think it is reasonable for the agency to do so. And I think that's what the court and cellular phone task force said.
No, it
It's
didn't have,
reasonable.
no, and in fact, I mean, in our case, we specifically noted that what could make a difference is if circumstances change. We have that in there. And that circumstances could change over time, then there would need to be another look. And that was what you all flagged in your notice of inquiry was things have changed, including the ubiquity and multiplicity of devices. And then when the FCC gets an answer back that simply isn't answering those questions, and then as Judge Wilkins has pointed out, doesn't even say we consulted the people who are in charge of studying these things. That just seems to be, you get a lot of leash, but at some point that leash goes too far and becomes unreasonable without a little bit of follow-up by the FCC to verify, just to pin down that the information is responsive.
Well, I hear your concern again about the cumulative effects here, but I think the predicate question to any assessment of the cumulative effects is whether there's any adverse effect at all from a single device. And as I said, the only substantiated adverse effects are thermal, which would mean that cumulative effects wouldn't be something that could cause injury, at least under the substantiated credible scientific evidence as it stands now. And
how do I know that the radio frequency interagency work group doesn't believe that there are non-thermal effects that should be regulated? How do I know that the committee that Congress told the FDA to create, this Technical Electronic Product Radiation Safety Standards Committee, doesn't believe that there are non-thermal effects that need to be regulated or concerned? I mean, my point is that you're asking me to infer a negative but without there being anything in the record that the agency that Congress said should look at this, the committee that Congress said should look at this, even looked at it. And then you refer to an interagency work group that you say looks at these things, even though there's nothing in the record about that work group or what they looked at or haven't looked at.
Again, I think that we formally solicited the views of other entities with expertise in this area. We made very clear that we wanted to rely on them. We relied on the views of expert agencies in adopting these limits in the first place, and no federal agency or body. Did you
solicit these committees, or did you just solicit the FDA?
At JA 165 of the notice of inquiry, we said we formally seek the input of all of the expert bodies in this area. And we left the docket open for 7 years, giving ample opportunity to weigh in, and not one of these bodies said you need to change your standards. And we're not arguing that silence should be construed as endorsement, but it shouldn't be construed as disapproval of the agency's existing limits. I think even if you construe it as neutral, all of the representations that we did receive, and again, the FDA it's undisputed that
you want us
FDA
to
has
construe it
primacy.
as deliberation, that silence should be construed as these relevance committees actually deliberated, actually reviewed the record and studies. So you are asking us to infer something that's significant.
Well, all that we're asking you to infer is what the Second Circuit and Cellular Phone Task Force said was reasonable, which was for us to presume that the agencies and bodies charged with staying on top of this area and regulating in this area and paying attention to the science in this area have done so. And yes, we're asking that you presume that the agencies with responsibility in this area,
even when the report that they send back doesn't reference, lots of relevant studies and lots of relevant issues, we still presume that they reviewed those studies and those issues.
Yes, I think it's reasonable for the FCC to presume that they did. As I said, the FDA referred to its ongoing monitoring activities and confirmed its responsibility in this area. And I don't think that there's any requirement that the FCC wait for this committee to speak as a committee, that it can't rely on the FDA's representations about the state of the science. Again, this committee is created in the FDA's operating statute and appears in the section right after FDA has been anointed the agency with responsibility in this area. And under the
You can't tell me whether that committee even exists or whether the committee reviewed anything having to do with this petition.
I can't sitting here. I don't have any personal knowledge about that committee. I do know, as I said.
Why shouldn't that bother the court?
Well, again, because the FDA weighed in. It's statutorily directed to be the responsible agency in this area. And I think the FDA, we know it does have primary jurisdiction over public health. I don't know that every other member of that committee does, but they are certainly well equipped to evaluate the science and make a representation about the sufficiency of the radio frequency emission limits. I mean, one other point, the FDA regulates in this area. They are responsible for promulgating the radio frequency emission levels for devices that the FCC doesn't regulate. So again, this is an important part of their mandate. And just as we relied on expert agencies in adopting the limits, it was reasonable to do so here. Just one more point on this. As I said at the outset, we weren't writing on a blank slate here. In 1996, we adopted these limits and we had the input of the FDA, the EPA, OSHA, and IOSH. So these limits don't reflect the views exclusively of the FDA. It was a considered and lengthy deliberative rulemaking, and none of them weighed in to say that they needed to be changed. I'd be happy to answer other questions of the panel.
I do have one. How difficult would it be to determine whether these committees and working groups exist?
I can easily.
Well, I mean, are they set up by regulation or that's my question. Is it a question you can answer with some sort of supplemental submission?
Yes. It is a factual question, and it's certainly one that we can answer in a supplement if the panel is interested.
All right. All right, are there any more questions?
None for me.
All right, Judge Millett.
More.
If there are no further questions, we ask that the petitions for review be denied.
All right. Mr. McCulloch, why don't you take a couple minutes and reply?
Thank you. I'd like to try to make about 5 or 6 really quick points. First of all, to follow up from the questioning about Fox, if you could take a look at 780 F3rd at 1024 to 1047. That's where the court discusses the matter that we were addressing. You might also take a look at the American Horse decision that we cited in our brief. It says that even at the high level of deference, the agency has.
I'm sorry, which pages in Fox specifically are you talking about?
1024 to 1047.
Wait, I have, sorry. Fox starts on 1027, doesn't it? I'm so sorry.
I may have that wrong. I was dealing with a printout, but it is in there, and I do apologize.
Okay.
I really do have to push back against the finding in the order in counsel's argument that there's no evidence of non-thermal marks. We don't have to go through it right now, but I would love to direct your attention to, when you get back in chambers, the exhibit that we distributed to the court for purposes of oral argument. There are 3 pictures in there, each of which show non-thermal impacts from radiation, blood-brain barrier damage, DNA damage, and then glucose metabolism responses. All of these are direct responses to and effects from exposure to non-thermal RF. So you just simply cannot say there is no evidence. All of this is in the record. The commission cannot say that there is no evidence when there are 1,000 peer-reviewed studies that show harmful effects from non-thermal. With regard to the agencies, the Interior Department, the EPA, the OSHA, a couple of them did respond to the commission in somewhat cursory fashion. Granted, you know what they said? They said talk to the NTP. They didn't say talk to the FDA. They said talk to the NTP. They deemed the NTP to be the agency with expertise here. And we know what the NTP found. With regard to the RFI-AWG, I cannot presently help you with the factual question you asked. We too would be happy to supplement. But I do know that there is evidence in the record indicating the RFI-WG after 1996 supplied information to the commission expressing significant concerns about the non-thermal only approach. They too had concerns with the thermal only regime. With regard to Judge Wilkins' questioning about remand, we of course, that's precisely what we seek. We think the commission failed to address the record that was before it. It did not evaluate that information, and we of course would very much appreciate the ability to provide even more information, because things happen every day. There have been developments since this order was issued a little over a year ago.
We can't look at developments after the record in this case.
I understand, and that's why we think that it should be considered on remand. As Judge Millett pointed out, the situation is far different now than in 2000 and 2004. In the science is far more robust. I was fascinated by the questions about cumulative impact and counsel's admission that when it comes to non-fixed sources, its rules do not account for cumulative impact, response to chronic exposures from any of these, much less mobile devices. And that is because they persist in this thermal only approach. But the evidence is clear that there are biological responses that are in many ways similar to what happens with thermal radiation. It is simply that it is an indirect response rather than a direct response. The same kind of health consequences occur. It just occurs indirectly through mechanisms like oxidative stress. Now, with regard to the contention that the consensus is the same, that is simply not true. Take a look at the chart on the right-hand side of our exhibit. The majority of studies now show that there are harmful thermal effects.
Were those charts that you submitted to us, are they part of the record?
It is a compilation of information that is in the record.
They're not from the record itself.
This particular exhibit is not in the record, but each of the squares is in, each of the images are in the record
Okay.
on the left and bottom side. And then the majority of studies chart comes from graphs that are also in the record. We just compiled. The commission insists there's no effect, but that is only because it insists on looking only at non-thermal effects. And that's the very problem here. When you're looking at the testing regime or anything else, yes, of course, you want to have a safety margin. When you're going around an obstacle, you want to give it a wide berth. The problem is the safety margin here. Everybody is so focused on the thermal effect that they're not paying attention to the ditch that you're driving into on the non-thermal effect side.
All right, you need to wrap it up, Mr. McCullough.
Thank you. I'd be very much remiss if I did not make one final plea. The commission did not at all consider individual impacts for those who demonstrated that they are presently being harmed. It made no provision for them. It did not recognize them. These were individuals who have just had their lives devastated. We respectfully request that the court vacate and remand and require the commission to engage in reasoned decision-making and respond to all the material points and comments raised. Thank you.
All right, thank you. Ms. Boiselle, can you get whatever information there is about the formation of these committees and working groups we've been talking about and submit it? Well, let's say that should be fairly easy. It's either there or they either exist or they don't. Let's say by 5 o'clock tomorrow, and then Mr. McCulloch, let's see. I don't know that there'd be anything to respond to because they either exist or they don't, but why don't you take another 24 hours if you have anything you want to submit in response that is purely factual? And do my colleagues have anything they want to add or request?
Or just can we find out the timing, if possible, when they were created? Not only what
Sure.
exists, but when
Yeah.
they came into existence.
Sure, that's a good point.
And if
Judge
you're
Wilkins.
able to, the membership, who's on these committees?
All right. And Judge Wilkins, anything from you
No.
about submissions? Okay.
No.
All right. Then I have one final question for Mr. McCulloch that has nothing to do with this case, but you practice law in one of the most colorful sounding towns I've ever heard. Where is Dripping Springs, Texas?
Dripping Springs, Texas is about 40 miles west of Austin, Texas.
Okay.
It is in the hill country and it is a beautiful, beautiful small town.
All right. Well, I'm glad I learned of its existence. Thank you. All right. Your case is submitted.
So we're holding this press conference following the Monday morning arguments in the U.S. Court of Appeals for the District of Columbia in the landmark case Environmental Health Trust et al. Versus the Federal Communications Commission. This historic case is filed jointly with Children's Health Defense, Consumers for Safe Cell Phones, numerous other petitioners, including Elizabeth Barris, Theodore Scarato, that is myself, Michelle Hertz, Petra Broken, Dr. David Carpenter, Dr. Toril Gelter, Dr. Paul Dart, Dr. Ann Lee, Virginia Farver, Jennifer Barron, and Paul Stanley. Environmental Health Trust et al. Versus the FCC seeks to have the court order the FCC to remand, vacate, and update its 25-year-old exposure guidelines for radio frequency radiation from cell phones, cell towers, Wi-Fi, 5G, and all other wireless networks and communication devices. And I'm here with Environmental Health Trust Counsel Ed Myers and Dr. Deborah Davis, President of Environmental Health Trust. Mr. Myers worked with the Natural Resources Defense Council in a successful challenge to an order of the FCC that sought to eliminate any environmental review of 5G cell towers and transmitters and small cells. For over 40 years, Mr. Myers has represented government, trade associations, and private clients in complex regulatory matters involving energy, telecommunications, and environment. Mr. Myers.
Thank you, Theodora. I haven't really prepared extended remarks. I can talk generally about the case and give you some reactions to the oral argument from this morning. The case concerns a 2013 notice of inquiry in which the Federal Communications Commission decided voluntarily to reconsider its safety and health standards as regards radio frequency radiation from wireless devices and infrastructure. Over the course of several years, the FCC received thousands of comments and including over 1,000 scientific studies and multiple submissions by individuals affected directly by radio frequency radiation. In 2019, in December of that year, the Federal Communications Commission decided that the evidence submitted was not adequate to cause it to rethink its safety standards. Those safety standards were implemented in 1996 at a time when most wireless devices were 1G or 2G, and certainly not reflective of the current environment where the country is being urged to move forward into 5G type devices. Usage of these devices has changed. The devices are more ubiquitous than ever. With 5G, the radio frequency radiation emitted by the infrastructure and by the devices will be nearly inescapable. The term has been used to call this electrosmog. It will be unavoidable. And there was considerable testimony and evidence, that is, in the record pointing up the harms from radio frequency radiation. And the basis of our complaint was that the FCC should have looked at this evidence, but did not. It relied on the Federal Food and Drug Administration's conclusory statements, but the Food and Drug Administration also did not look at the evidence. And judging by the reaction of the judges this morning, I think they agree with that. We are optimistic, but not certain, that we will get a remand, a vacatur of the order terminating the notice of inquiry, and a reopening of that inquiry so that the FCC can do a better job, a legally adequate job of assessing the evidence. And we're confident that if it does that, it will realize that the regulations, the standards that are currently in effect from 1996 are not adequate for today's environment. Arguably, they've never been adequate, but today it's even more certain that they're inadequate and need to be revised and updated. I'm happy to take any questions after Devra makes her short statement.
Thank you. Dr. Davis?
Yes, we were delighted with the hearing today because it's clear that the judges did their homework. It was very impressive to see that they really got into the details of the extensive record that was developed by Mr. Myers and Mr. McCullough, including thousands of submitted peer-reviewed studies. I thought it was quite interesting that the judges really honed in on this question of how the FCC relied on such thin evidence from other agencies. And in the record, there is a letter from Norbert Hanken when he was a member of the radio frequency work group, in which he urged that the FCC revise its approach to cell phones, and that record of that letter has never been answered. Most importantly for us, just yesterday, the Swiss government has a committee that it has appointed. I think they've been in existence for 6 years, that completed an extensive, comprehensive review of all of the evidence, including experimental studies, as well as epidemiologic evidence in people and other studies, and concluded that there is evidence of harm happening at levels for which there is no heat. So this is exactly the point that we've made in our brief, and it supports what we're doing. And one of the judges asked, are there any international standards that are more strict than the United States? And the answer is yes, and one of them happens to be Switzerland, where it's the home of the World Health Organization. They have taken the issue of RF very, very seriously, and we're pleased that the judges even raised the question of other countries, because we are in fact behind a number of nations, and I think that's a point that we will be making to the court in our reply shortly. At this case, it was argued by Scott McCullough. Children's Health Defense has separately filed a suit, and our suits were joined by the courts. So we've worked together to file briefs in this case, and Mr. McCullough presented the argument at the hearing. So we look forward to taking your questions, but I wanted to just say the science on our issue, which is what drove Environmental Health Trust to engage in this lawsuit, is strong and getting stronger. And I was pleased to see that the courts appear to agree with that. Let's see what happens next.
Thank you, Dr. Davis. I'd also like to mention that there were amicus briefs filed in our case. The National Resources Defense Council filed an amicus brief, and the need for environmental review. And that was signed onto by mayors and council members from several states: Maryland, Massachusetts, Michigan, California, and Hawaii. Telecom attorney Joe Sandry filed an amicus brief as well, and that include a statement from Dr. Linda Birnbaum, former director of the National Institute of Environmental Health Sciences and former director of the National Toxicology Program, talking about the unfounded criticisms of the National Toxicology Program. By the way, criticisms that the FCC brought in with their reply to our joint evidentiary brief. And Dr. Birnbaum talks about and quotes Dr. Ronald Melnick's published data showing that those are unfounded criticisms from ICNIRP and the FDA, and states, overall, the National Toxicology Program findings demonstrate the potential for radiofrequency radiation to cause cancer in humans. The Building Biology Institute, as well as the Kleiber family, filed briefs on injuries sustained from exposures which are within FCC exposure guidelines. And all of these briefs are exceptional readings that lend a lot of important information. I also wanted to point out the judge has asked a lot of really important questions, but we also have on the record and mentioned in the joint brief letters from the interagency work group, which was mentioned because just to kind of drill it down, a question that many people have is, well, who is making the decisions about what the science says? What expert groups are making those decisions? And there used to be, although as we understand it, it's all but defunct, interagency work group that included representatives from the FDA, EPA, and numerous health and environmental and other agencies in the US government. And there are letters signed by several of those members on the record, which talk about problems with the current limits for wireless that we have right now, wireless radiation, such as increased sensitivity of different parts of our body, different tissues, children, modulation, which is really important. So that is on the record. And I am thankful that this house of cards, this mirage, that there is safety, there's some sunlight getting on this story. So I had some questions for Ed, the first questions that many people are asking, which is, can the FCC appeal? And if so, what would that look like? And any thoughts on what the new administration, any actions by the new administration and what they can do in regards to this issue?
If the FCC gets an unfavorable decision from its point of view, it can do two different things to try to appeal it. It can ask the entire court in the DC circuit to rehear the case en banc, or it can file a petition for certiorari with the US Supreme Court, which the Supreme Court may or may not accept. But those are its only two options. Otherwise, the case would be remanded and sent back to the FCC. What was the second question? I can't hear you.
Sorry, the Biden administration, if there's anything that the administration can do in regards to this issue, any changes that could happen or action at the federal level?
Well, certainly the Biden administration could reopen the proceeding unilaterally. It doesn't have to wait for a court decision, which would give us the relief we were seeking.
Right.
Or it could take even more drastic action, which would be to move forward based on the evidence with a new rulemaking. So it has any number of other options it could pursue, I imagine, but it's certainly free to do as it chooses, provided it gets the votes from the commission.
Yeah.
Thank you. Dr. Davis, do you want to mention about our drafting a letter to the Biden, the new administration?
Thank you. Yes, we're working with Professor Paul Ben-Ishai in Israel, where the standards are much more strict, to write a letter to the Biden administration where we're going to urge them to take this action. we're not in this lawsuit in order to just prove a point. We're in it because we think that standards that are 24 years old need to be changed. The Israelis, for example, would never have a cell tower right on a school, right near a school. There are regulations controlling that. They limit the amount of wireless radiation in schools, and like a number of countries that we have on our website, there are many that have stricter standards than the United States, and particularly with respect to schools. So I think there's a lot going on that is in support of what we're trying to do.
Thank you. And there are several countries, and I'm going to get together a graphic after we go through a few questions showing India, Russia, China have much more stringent levels of allowable levels for radio frequency radiation exposure. And of course, as you mentioned, many countries don't allow cell towers on schools or restrict them in neighborhoods, and have actually limits that are for what they call sensitive areas, which would be near homes, schools, hospitals, parks, and so forth, where they have more stringent limits or policies that are generally accepted where they have more stringent limits.
And as a matter of fact, as you refer to ICNIRP, and I assume most people are aware, it's the International Commission on Non-Ionizing Radiation Protection. And it is a self-appointed, self-monitored group of about 12 or 13 scientists, many of whom have direct or indirect ties to industry. That is the standard. That is the basis on which the FCC is relying at this time, even though many experts who are not part of that, but are experts in the field, have questioned the view of ICNIRP. And countries like India have instituted standards that are 1/10 that of ICNIRP. So there's a big challenge to what ICNIRP has said. And again, their work is being updated now. I note with some interest that a member of the new Swiss committee, I think was chaired by Mikey Mevison, who is an outstanding toxicologist, but a member of that committee for Switzerland is also a member of ICNIRP. So perhaps that augurs that ICNIRP is going to be making a change as well. I'm referring to Professor Martin Roosli, but I think it's too soon to say.
Thank you. I had a question for Ed. The judges asked some fairly tough questions of the FCC. Is it your sense that the court will at least remand the order for further work?
Well, that is the part of the relief we're requesting. I'm very hopeful. You know, I don't want to overcommit, but the judges' questions were very challenging to the FCC, so we're very hopeful that that's the result we end up with.
Thank you. What do we know about these committees in the FDA that they keep bringing up? Is there hope that they will adequately review the health evidence? I would just like to add something before we end. Well, I'm going to half answer that question and say that the FDA is not tasked to review issues related to impacts to birds, bees, trees, or our natural environment. So at least they don't have expertise in that. So that is one of the critical issues here, because even if the FDA did review, do they have the expertise themselves to look at the natural environment and wildlife? Do you want to add any more to that? It's the committee.
May I point out that the evidence on wildlife has been accumulating. A letter was sent officially from the Department of Interior Fish and Wildlife Service to the FCC in 2014 by Albert Manville, who was then an expert for the Fish and Wildlife Service, sorry. And that letter specifically identified problems with wildlife, birds in particular. Subsequently, in the record, we have submitted extensive evidence on how 3G, 4G, and 5G pose serious risks and threats to growing plants, including a meta-analysis, a machine learning analysis of what had been done on studies on plants alone. And there was a machine learning analysis on in vitro tests. And I think it's very important that at the very end, our counsel noted that if you look at all of the evidence at this point, combined, that the weight of the evidence, particularly in independently funded studies, clearly shows that non-thermal levels of this radiation can damage a number of things, including, of course, the fact that there are individuals who suffer greatly from sensitivity to this. They are experiencing illnesses at levels that others don't, but they are effectively, increasingly unable to find a place to live in modern society. And this is a serious and growing problem.
Thank you. This is it's been documented. There were so many comments from people who've been injured and who are looking for a safe place to live. And unless we have policy change, it's impossible to find a place. And especially with, and someone brought up, satellites. How will this decision affect the satellite deployment?
And that's a good question, because in NATO, which we are now part of more officially again, in December of 2019, issued a declaration on the importance of 5G as a question of defense. And I think we want to be clear that the technology properly does belong in national defense and national security, but wireless is not the way to go. We have argued and have submitted to the record that fiber optic cabling is a way to solve many of the current problems that we have. And in the letter to President Biden that we will be issuing, we specifically call for a massive jobs training program to train people to install and distribute wired fiber optic cable, which should be available as a right for municipal broadband. We think that it's important for people to treat access to the broadband as a public utility and public right. That will help to eliminate the digital divide that has affected our children now during this pandemic, when they have been supposed to be in Zoom school, and many of them have not had access to Zoom. Parents have had to drive cars to parking lots outside of stores so the children can get their homework done. But if wired internet service were provided in urban areas where it can be provided, this would substantially alleviate the problems of transmission. And it's something that we're very encouraging, has to be considered and looked at very, very seriously.
Thank you. So I wanted to review a few things that people are asking. And one is, Ed, if you could talk about the timeline, when we will expect an answer. And I should say in advance, yes, we will have posted on our website, ehtrust.org, this oral arguments, as well as all of the briefs. The briefs are on our website right now. But Ed, if you could answer that question about the next steps that we have in the case, that would be great.
So the court asked the FCC within the next 24 hours to supply it with some supplemental information concerning a technical committee that's established by statute at the FCC, and also concerning an interagency working group, radio frequency interagency working group, that at one time at least functioned, but I don't believe is functioning currently. The FCC has 24 hours to provide that information, and we have 24 hours thereafter to respond. Those responses will be factual in nature and not argumentative. The court
One of the
only
facts,
interested in facts. Once that's done, it's really a waiting game, waiting for the court to issue its decision. That can take anywhere from 6 to 12 months, more or less. It's hard to predict how long it will take the court to issue its decision. And then based on the decision, the losing side can decide whether to seek further review or not, as I described earlier.
One of the factual things that we have to stress is that the FCC has for years used a 30-minute averaging time. And we know from a lot of research that's been done that 30 minutes is far too long an averaging time for estimating effects, and that you need to look at peak exposures over much shorter periods of time, because it's not the total power that's important, it's the pulse. And the pulse of the signal, which is irregular and repeated, can be very important, so that the FCC has basically argued, well, since these things are weak, we don't need to review them in the same way, and they have no, we assume they have no biological effect. That is in fact the reason why, when the FCC responds, the FDA Technical Electronic Products Advisory Committee will say, we've never looked at cell phones. They have not, because they have been exempt from the agency's review.
Thank you. If we, actually, I have a comment here from Dr. Joel Moskowitz of UC Berkeley. I investigated the radio frequency interagency work group in 2015. It was almost defunct then. The few remaining members called it a support or interest group without any statutory authority. A few years ago, the FDA removed this group from its website. I suspect the group no longer exists, as two of its key members have retired from the federal government. Thank you, Dr. Moskowitz. And his website and blog is Safer EMR, Joel Moskowitz, and I can put that information in the chat. I'll also mention and add into that we have repeatedly written federal agencies, and we have asked who is a member of the radio frequency interagency work group? Where is the agenda? Where are the minutes? Where is the information? And we have received not really full answers. In fact, I have communicated with the FDA, who said at one time in their communications that they didn't receive a presentation of the National Toxicology Program results. So if there's no agenda and there's no notes, what are they doing, and are they doing anything? We don't have any documentation that they even have that they've made a determination on this issue.
I think Dr. Moskowitz is correct to surmise that there is no evidence that they really weighed in on this issue or on any others. And further, it will be very interesting to see how FCC counsel responds to this, given the fact that we have repeatedly requested what consultations were made. Moreover, and the timing is important here. In December of 2019, they closed the record with a very thin justification. And then in January of 2020, they issued a report, anonymous report, with no evidence of any review of it, that they said was on cell phones and health. It was really just on, as judges pointed out this morning, that report was solely on cancer and cell phones. And that is a ludicrous effort by the agency to put together a scientific document that would justify the actions that it had taken a month earlier, because that document only looked at cancer, and it didn't even do that. It cherry-picked the studies. It excluded studies of Leonard Hardell, one of the most distinguished epidemiologists who work in this field. Unfortunately, Sweden started using phones sooner. They had more data, and we have explained in some length about why the case control method is so important. But cancer is not the most important issue here, and it is the most difficult to study. And I say that as a cancer epidemiologist who's a fellow in the American College of Epidemiology. We have to be very careful not to say that we insist on proof of human harm before taking steps to prevent it. That is why the work of Dr. Birnbaum is so important here. Dr. Birnbaum's amicus brief, which I urge you to read, you can find on our website, is part of the Joe Sandry submission. And in it, she clearly explains that why we test animals in order to predict harm in humans and prevent harm in humans. So what we can say is this: every agent that we know for sure causes cancer in people will produce it in animals when adequately tested. That fact has driven the United States and all other modern countries to support animal testing as a way to protect people. And yet we are involved in a debate of whether we can prove enough people are sick. And we think that it's time for that framework to end. And we need to start protecting and public health and preventing harm, which is we're really encouraged that American industry will know how to do this. Just like they created airbags and seatbelts, they will figure out how to make phones and technology safer.
Mr. Myers, could you answer the question about NEPA and how important this case is for NEPA and environmental review?
Sure. So the record contains a substantial body of evidence showing that the radio frequency radiation from the infrastructure used to support wireless devices presents a real threat to the habitat, to the environmental habitat, birds, bees, and trees, and whatnot. And yet the commission, the FCC, failed to analyze any of that evidence. Under NEPA, the commission is not required to come to any conclusion about what the evidence says, but it is required to take a hard look at the evidence and determine whether there's a significant impact on the environment. It did not do that. Because it did not do that, and because the evidence shows that there is a significant impact on the environment, the commission fell down on the job and did not perform its NEPA responsibilities. So as part of a remand, we are looking for the court to direct the commission to do a thorough NEPA analysis. That would begin at a minimum with an environmental assessment, usually termed EA, of the likely impacts of radio frequency radiation on the environment. If the impacts are found to be significant, as we think they would be, the commission would be required to do an environmental impact statement. So we're hopeful that the court addresses that issue. We raised it in our briefs. It was not addressed to any significant extent, if at all, during oral argument. The court dwelled mostly on the Administrative Procedure Act issue, which is similar in that it requires reasoned decision-making. And again, the commission fell down on that job too.
Thank you. And I'll add, oh, go ahead.
Go ahead.
I was just going to state that we did a FOIAs about whether there was an environmental review before the deployment of 5G and the densification of small cells, and got back answers where they declined to send us, they maintain the records and were not provided those records. But it would seem that if you're going to deploy a million and millions of new antennas into neighborhoods and so forth, and all these new poles, that there needs to be a proper environmental review.
Right.
And as you know, we have been on our website recording many examples of communities and countries that are objecting to 5G. There's a growing number of them, and that have asked for review and information about them. We take exception to the Oregon State report that was issued, and we'll be talking about that later. But it is important to note that there's a growing consensus that the 5G has a lot that it's lacking. Right now in China, in some areas, they're turning it off at night, and they found that the energy use of 5G is so great that it's not resulting in any savings whatsoever, and the public in China doesn't seem to particularly want it. So it's going to be very interesting to see what happens with the marketing of that here. We think that 5G belongs in medical and military complexes where it can be wired in at the higher frequencies with a cable, and that the wireless part, it really does not belong in public space.
Let me add, the FCC really has a history of ignoring its NEPA responsibilities or trying to avoid them. In the prior case that I was involved in, I believe in 2017, the Kitawa case, the FCC had issued an order that we challenged, finding that NEPA simply did not apply to 5G infrastructure, so-called small cell facilities. We won that case, and the court remanded it and essentially found that NEPA does apply to those types of deployments, and the commission has an obligation to consider NEPA when authorizing those types of facilities. Now, in this case, the current case that was argued this morning, we argued NEPA, and many people raised NEPA in their comments in the rulemaking, in the notice of inquiry proceedings, saying NEPA procedures should be applied. In the order that we challenged and was argued this morning, the FCC did not even address those arguments, which led us to conclude that they waived their position on NEPA and really had no defense to our claim that NEPA applied.
Thank you. I think it's so important also to clarify, if it's not, that the limits that we have were set for humans. They are inadequate to protect humans, but even if they were not set for birds, bees, trees, natural environment. And in fact, there is none that we are aware of. There has been no review of the impact on the natural environment and wildlife and the development of safe limits, because of course birds will perch on antennas, insects, bees will fly and be closer than people in many cases in regards to the cell antennas on cell towers and small cells, which are of course going to be in front of windows and in front of homes as well. So someone asked the question, can the FCC say we'll take another look, and then a year from now say we looked and we still don't see anything of concern? If can that happen?
And in fact, theoretically, it could happen. But I think that with a new administration and new people running the FCC, we have a better chance that this will get a really full, reasoned, hard look. And there is a question was asked about whether there's protection from radiation emissions for electronic products. And actually, I think we will find that the FCC has exempted cell phones from that kind of review because they have maintained in the beginning that they were too weak in power to have a biological effect. Now, in fact, it's not the power alone, but the pulse and particularly the peak that we are most concerned about. I see that one person asked what NEPA was, so we better explain again. It's the National Environmental Protection Act. And that law, it's a federal law, requires that any agency undertaking a major federal action must engage in the analysis that Mr. Myers explained, an environmental assessment. In fact, the FCC has argued that the 5G system is not a major federal regulation. And we think that that flies in the face of reality. You're talking about 1 million new antennas. You're talking about needing to cut down trees in many instances, because for 5G wireless signals to go, they don't go through trees. They don't go through a lot of things. And so that's why on an average city block, you might need 15 antennas to ensure that the block is sufficiently covered. And I don't know quite how it works for buildings that are 50 to 100 stories tall. But if all of these things were wired into the facility in the first place, if people were using wired Ethernet connections, and there can be innovations in technology that will develop, then we would all be much better off.
Thank you. One other question was about ICNIRP and the World Health Organization, and I wanted to add something about the WHO, the FCC, and also, actually, there's a third theme. I'm trying to get themes that are coming out of these questions, which is what did the FCC say that was inaccurate? And one of the things the FCC said was that they relied on other organizations to help them, because the judges were saying, well, the FDA is only about cancer and cell phones. What about everything else? And actually, the World Health Organization, the IARC decision was not referenced. And the World Health Organization EMF project, very important that everyone on this call be aware that there are two entities within the World Health Organization. So when we, well-meaning people go and look up cell phone radiation and they go to the World Health Organization site, it has the logo, World Health Organization, and there are these fact sheets up. Those fact sheets, which say there's no proof of harm, or I don't remember the exact phrase, they were written. We don't know who wrote them, but we do know that there is a lack of transparency about who wrote that information. It is not the International Agency for Research on Cancer, which classified radiofrequency as a possible carcinogen in 2011, and whose advisory group has said it's time to review the science because of the National Toxicology Program results and the Ramazzini results. It's a different entity than IARC, the EMF project, and they have not reviewed. Those fact sheets are not based on a large report that looked at all the science. In fact, the last document that exists on this is from 1993, and it even says that they're working on an update, a monograph that will update their 1993 research review on radiofrequency radiation. So it is details that, you know, the devil's in the details here, and it can get complex fast, but really it's a house of cards. That's how I see it. There is no there. There is no big group of scientists who are looking at all the science and making determinations based on their expertise, and they've looked at everything. So I'm thankful to see that it seemed the judges were aware of that. I mean, Ed, I guess my question is, having litigated before and worked in other cases, what did you think about the judges' responses and questions?
Careful here.
Well, I was very pleased and surprised by the judges' questions. They clearly had read the briefs. They got into more detail than I had anticipated. The judge say to the counsel for the government, tell me why I shouldn't vote against you. I thought that was extraordinary. It gave me a lot of hope, but I don't want to, get out of in front of my skis too far, but I am very hopeful.
I think that I agree. I was quite impressed with the questions that the judges asked. They obviously had really done a lot of work, and the complexity of this case is such that I think the fact that they gave us just 10 minutes, and by the way, took a lot more in their questioning of our representative, I think it all augurs well. Frankly, the new Biden administration could fix all of this with the stroke of a pen. They could simply say, we're reopening this inquiry. We want to update the science. We want to include environmental impacts. We had an amicus brief from the National Resources Defense Council that was, I think, very helpful and quite instructive on just that point alone. And I wonder, Mr. Myers, did the lack of questions about NEPA tell you that the judges have already decided we're correct on that?
Well, that's really hard to say. I don't know why they didn't get to NEPA, other than I think they were ready to decide the case, or inclined to decide the case, solely on the APA, the Administrative Procedure Act issue. This could be a replay of what happened in the Kitawa case, where they decided the case solely on the APA issue and didn't need to get to the NEPA issue. And it's a matter of judicial economy. It's common for courts to say, we don't need to get to the other issues. This one is enough for us to base our decision on.
Of course, our brief mentioned the Administrative Procedures Act, the APA, the National Environmental Policy Act, NEPA, as well as the Americans for Disability Act. And it is interesting that, as you note, I think the Administrative Procedures Act was so clearly violated here that is going to be the focus of what the judges will convey. What that act requires is a record of reasoned decision-making. And what the FDA did, what the FCC did rather, was to take an inquiry that began in 2013, that had previously begun, an earlier one had begun, I think in 2008, and never been finished, open it in 2013 as a notice of inquiry, collect, I believe, more than 1,900 different submissions at one of the times I looked, and never show that it had analyzed the data, evaluated the data, or in any systematic, rational way read any of the entries. So it's not that each one of them should be accorded the great significance, but the failure to have a record of having reviewed that extensive submission was in fact a failure of the Administrative Procedures Act,
Right.
which requires that the agency show a reasoned record of decision-making.
Right. Okay.
I'll add that in the amicus brief by NRDC, there is a letter. It's at the end of the brief. I put the link in the chat, but all the way at the end, it was communications that I had with the Environmental Protection Agency, where I asked, please send me the staff member of your respective, who is your respective agency, because I was actually asking numerous agencies, who's on the interagency radio frequency work group, as I have repeatedly tried to get this information and it is never provided for me. And the EPA response is, the radio frequency interagency work group is an informal forum for exchange of information, and the group does not meet or to set or advise on policy, rulemaking, or guidance. The group has not met in more than 2 years. And that same letter also documents the EPA stating that they have no funded mandate. On the record is the documentation showing that while they were in development of safety limits, the Environmental Protection Agency, related to human health and also to consider modulation as well, they were defunded. So they gave a presentation, they were working on it, they were tasked to do it. And then that action, the EPA did not take any further action to finalize. In fact, we don't have federally developed safety limits related to radio frequency radiation in the United States. As stated on the FCC website, actually, I think until recently they moved that sentence down somewhere, but we assume that of course we have safety limits that were developed by all the experts, but in fact, that assumption is not true.
And even for the Occupational Safety and Health Administration, where you would think there would be standards, we allow workers to be exposed to more in terms of the way they discuss standards, but there is no routine monitoring, there is no surveillance. The same is true for towers, of course. Aside from the outstanding work done by the EMR network, there has never been independently evaluation of emissions from towers. And we all want to believe that everything is safe and secure, but then there really does need to be a system of monitoring and surveillance. Again, in Israel, there is. And in India, there's a better system. So the United States needs to catch up with these other countries.
And also in France, one of the things we didn't touch on is the cell phone test system, which is not the way we use devices. So part of the case was also that the way cell phones and wireless devices are tested don't reflect the way we use them. They are not tested in body contact positions. However, people use devices. Babies are hugging devices against their chest. Yet, when phones are touching the body, they can, according to publication by Om Gandhi, which is on the record and has been known for a long time, and all of that documentation is actually on the record as well. And you can also go to PhoneGate Alert for information on this. They can exceed the FCC limits for localized, meaning right where it's touching the area that is getting the most exposure by up to 11 times. Again, the PhoneGate Alert Association has done incredible work on that as well. I just have a comment, and then we're going to close if anyone wants to add anything else. The FDA.
I noticed that Dr. Linda Birnbaum
I was going to quote.
has written that the FDA has a responsibility to work with the FCC in setting standards for RFR. The important thing to understand in the history of this is in 1999, as Dr. Birnbaum says in her amicus brief, the FDA requested a long-term NTP study of cell phone radiation, recognizing the growing use of cell phones at that time. This is 1999. It took, unfortunately, a decade, basically, to get that study done and finally released. And the study went through an unprecedented level of peer review. Never before has anything in the NTP gone through that kind of review. And after that peer review, the peer reviewers, some of whom worked for commercial companies like Mobil or Procter & Gamble, they looked at the data and they said that these findings by the NTP are strong and clear and compelling. And they concluded that there was evidence of a cancer risk of a rare tumor in the heart, and also that they were concerned about hyperplasia, which means a proliferation of cells in the brain, in the heart, in the thyroid, in the liver. And further, the NTP released studies showing DNA damage in their animals after just 90 days of exposure to cell phone radiation that did not produce heat. So for all of these reasons, it's really important to appreciate that the FDA fundamentally erred in dismissing the National Toxicology Program, and that this is inconsistent with the views of experts in the field all around the world who take this finding quite seriously. And the Ramazzini Institute corroborated that finding with even lower exposures.
Okay.
So thank you very much to everyone. We actually have to continue work on the case. We have supplemental information to provide, and we appreciate everyone's support. We will be following up with more information. Please go to Environmental Health Trust, ehtrust.org. For more, we have all the documents, the amicus briefs, the appendix with all of the science that was submitted. A special thanks to Scott McCullough, Children's Health Defense, Robert Kennedy, as well as the petitioners. And I'm thankful that everyone has worked together to get this far. Thank you so much.
And thank you, Theodora and Ed. We really, it's a long journey, and we're very pleased to see that we've come to this point, that at least the issue has seen the light of day, and we really did get a day in court. Thank you.
Okay.
Thank you, Ed.
Probably the most important thing I did, I was involved as a young scientist in the committee that actually reviewed the data and recommended that there be no smoking on airplanes. You may be shocked to hear that it was even a question for science at the time, but it was. And when I look at what we know now about mobile phone radiation, I see some very interesting similarities.
A growing number of prominent doctors and scientists are raising warning flags over radiation this morning, and your kids could be facing a greater risk of exposure.
I think the most important study is a study by the National Toxicology Program in a classic large carcinogenicity test, one of the largest ever performed, and for that matter, one of the most expensive. They found increased risk of the tumors, which we believe radiofrequency radiation is causing in man. Particular tumors called schwannomas. In the rats, they were in the heart. In humans, they're often in the nerve, the ear nerve, the vestibular nerve.
Cell phone providers say they follow all safety guidelines put into place by the FCC. The current FCC safety standard was developed nearly 20 years ago.
The manufacturers actually tell people in the instruction manual, which I never read, not to put the cell phone against your ear.
It does say exactly that. There's the BlackBerry, for example, warns to keep your phone at least 0.98 inches away from the body when transmitting. With an iPhone, for example, it's 5/8 of an inch.
At this point, the evidence has become sufficiently strong that cell phone radiation is a human carcinogen.
A major development from California's Department of Public Health. High use of cell phones may be linked to certain types of cancer and other health effects, including brain cancer and tumors, lower sperm counts, headaches, and effects on learning, memory, hearing, behavior, and sleep.
If it was a real problem, I would know. If it was a real problem, the government would protect us. How come I'm not hearing about this? They're all things I've heard when I give seminars. You know, I get up there and they say, oh yeah, if this was really a problem, they would have told us. I am they. I am a, legitimate scientist, and I am telling you.
Did you know? That cell phone, the one in your pocket, emits radio frequency radiation. As long as your phone's turned on, even if you're not talking or texting.
The American Academy of Pediatrics in over a dozen countries recommends reducing children's exposure to wireless radiation.
When using a cell phone, I always keep it away from my body. I use speakerphone or a headset like this.
To stop microwave exposure, I put my phone on airplane mode and turn off Wi-Fi and Bluetooth function.
I hold the phone at a distance and make sure it's not touching my body.
Cell phones are not toys. Children's brains and bodies are still developing and are vulnerable to wireless radiation. Practice safe and responsible habits with yourself and your children.
When using the computer, I always try to make sure my connection is corded, not wireless.
Remember not to use your cell phone in the car. The phone works at higher power in metal surroundings and bounces around, increasing your family's radiation exposure.
For their safety.
For your safety.
Because children are more vulnerable.
Remind them.
Remind yourself.
To limit your microwave radiation exposures.